Hello, everybody. Assalamu alaikum, Sastakal, Namaskar to all the listeners. This is attorney Shah Peerally for the Shah Peerally Law Show. And we are going to talk, of course, about immigration law and also about debt settlement. I wanted just to check with Michael if my voice is clear. So hopefully we're going to talk about many issues that are related to immigration law. But again, before I start, anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And today we're going to take the calls in a few minutes. 657-510-657-1170, 510-657-1170. And today we are going to, of course, talk. We already have a caller, but before I take the caller, I just wanted to mention we are hearing a lot of kind of horror stories right now, so you need to bear with us because a specialty occupation is becoming a major issue. We're going to discuss a little bit about that today. And also one thing which is becoming a major problem is day one CPT issues and also multiple same level education CPTs. So we're going to discuss about all this and also about some of the issues that people who are going to file for citizenship are going to face. So let's take one by one. And first, let me take a caller, Michael, and then we'll move on. Hi. Hello.
Hello.
11. Hi, Abhinav.
Hi, how are you?
I'm doing well. What can I do for you?
Hello. Your voice is actually low.
Can you hear me now? We're having some issue because okay, sorry, I'll speak a little bit louder because we have kind of merge of the phone, so sorry for that. If you can hear me, then let me know, okay? If you cannot hear me, let me know. Okay.
Yeah, I hear you, yeah.
Okay, go ahead.
Yeah, so my question, I have a question on basically on H-1B. So currently on H-1B, how long you can work from a different country on H-1B? Let's say we're talking about 6 months timeline or a year timeline.
What do you mean work for a different country? So you mean going outside and working?
Yes.
Okay, once you leave the United States, there is no H-1B. The H-1B gets cut off, at least the status, and when you come back, it resumes. So you can work as much as you want. And when you come back, then there is an issue. As long as your company maintains your H-1B, that means no need to maintain, but doesn't revoke it. You can always come back on that if you have a letter of employment.
Yeah, but let's say they have a green card currently in process and they are running my payroll on H-1B currently. So that doesn't affect in any way?
It's not it doesn't affect in any way, but it doesn't affect it. You can wait for your green card from outside. Do you have an adjustment of status file or just the I-140?
Currently, I-140 is in the process.
Okay, but you don't have an adjustment of status. Your dates are not current, right?
Say it again?
Your dates are not current, right? And the visa bulletin, where were you born?
Born in India.
Okay, so you have a waiting time, EB2, right? You're on EB2?
Yes, EB2. I mean, the green card process just started. I just got my H-1B, so green card process just started like in June. And planning to move to a different country, most likely in Canada. And because my wife has a job there, and my employer allowed me to work from home. So I was thinking if I go to Canada and just work from home from there, then would there be any complication because my I-140 is currently, I mean, they're filing and it's in the process.
A very good question. No, there's no problem actually, because once you're outside United States have no say on your H-1B. Whether you have an H-1B or not, you don't get affected. And even the H-1B is canceled by the company, they can always revive it by filing an extension. So, and as for the I-140, technically there's no problem because the I-140 is very independent of all this. So, no, bottom line, there's no problem. But I would recommend at least filing the I-140, get it approved, and then leave.
Okay, yeah, that makes sense. Okay. Yeah, currently
there's no problem because H-1B stops as soon as you leave, so you don't need it when you're outside. So you can always work as much as you want as long as the country where you go allows you to work. You can work remotely. You're just like a contractor working outside. U.S. has no say in that. And then when you decide to come back, make sure your H-1B is still alive. Otherwise, revive it, and then you can come back. And then the I-140 will still be there. That's it.
So it looks like I have to talk to someone in Canada to see like what kind of taxes and other implications I can have if I'm working from there.
Yes, because you will be working as if you're working in Canada, even if you're working for a U.S. company. So I think I cannot pronounce for Canada. You might want to talk to an accountant there. And it's so tax law, I don't know much. But if you look at it from a logical perspective, you're not doing really work for the U.S. because it's just like all those contractors working outside. They don't even have an H-1B. So H-1B has no value when you're outside. It's only when you're inside that it's important.
Okay, sounds good. Thank you.
Okay. Good luck to you. That's a very good question. Thank you, Abhinav. So, ladies and gentlemen, this is Attorney Shah Peerally, and we're live on air. Today I have Michael on the board with me. Thank you, Michael. And the number to call to the studio, 510-657-1170. 510-657-1170. I was talking about all those complications coming up now. One of them, a specialty occupation, is becoming a major, major thing. And a lot of people are seeing denials, and we are seeing also a huge number of denials, by the way, on H-1Bs, not only from our office. Luckily, we're not seeing that many, but still, they are coming, and many of them are becoming major problems because people have been there for years, and now suddenly the USCIS is saying that your job is not a specialty occupation, which is kind of very unfair. But there are ways to deal with that. There are few case law that came out from the AAO that you might be able to use. And also you might want to look into getting what we call an evaluation from a credential evaluation company on the specialty occupation issue. So all this you can add up to make a possibility of winning a specialty occupation issue on H-1B. Having said that, many jobs next year are probably not going to fall into a specialty occupation, which, just to let you know, in order to be qualified for an H-1B, you have to be in a specialty occupation. And the definition was by law that I think we have another caller. Okay, let me take the caller. Hello.
Hello.
Mr. Shah Peerally, you're live on air. Abhishek.
Hey, Mr. Shah, this is Abhishek here. Just an additional question for the previous caller. So I have an approved I-140, and if we apply for a Canada PR, do I have to disclose in my green card application that I have filed my PR for Canada?
Technically, no, because the I-140 doesn't have is not the I-45. So at this point, there's no conflict of green card, because one thing which happens when you cannot technically have two green cards at the same time, by the way. You can have one citizenship, one green card. You can have two citizenship, two green cards. But you cannot have, Canada also is a permanent residence, just like here, green card. But at the I-140 level, there's no requirement really to disclose that. At the I-45 adjustment of status level, then yes, you have to disclose it, but only when you get the PR, not before that. Okay.
Oh, not before that. Okay.
Okay.
Okay. Thanks a lot.
Okay. A lot of people actually are moving to Canada, by the way, and I heard Quebec is taking a lot of people who have experience in the U.S. So if anybody need help, just send us an email, and we will introduce you to a Canadian lawyer who can help. Okay. So.
Sure. Thank you.
Thank you. Okay. I think I have another caller, right, Michael? Hello.
Hello.
Hi, Prashad. This is Shah.
Hello. Hi. Your voice is really low, but anyhow, thanks for taking the call.
You're welcome. I'm sorry. I always get these technical problems.
Yeah, that's fine. That's okay. I think it's manageable. So the question I have is probably, I don't know, it is similar to the other callers today. See, I have filed my adjustment of status. So I filed it in March. I'm on L1 and in EB1. However, I don't know when I would get the date for the interview. I've just been waiting. But there is a need, health reasons that I might need, my parents, so I might need to move to India for some time, at least 6 to 8 months. So I'm on L1. So how do I continue my green card?
Okay. What I would recommend if you're planning to move, get an advance parole. I don't know, they probably did that.
Yeah, I do have an advance parole.
Okay, then as long as you have the advance parole, you're safe. You can come back whenever you want as long as the advance parole is valid. You can also use the L1A, by the way, when you come back, but it's good to have the advance parole as a backup. But yes, there's no problem in doing that.
Yeah, but what is the chance that, like, for example, if my employer doesn't support me for so long, should I forego my green card application, or is there a way I can continue that?
Well, if 6 months has passed, 180 days have passed, and you can move to a same or similar position to another company or your own company, you might be able to keep the AC-21, and of course the requirements need to be met. You might be able to transfer the green card to another company. So if this happens, then give me a call at the office. We'll guide you what to do, because this is a long process. It's a case-by-case to match it. The number in our office is 510-742-5887.
Could you just repeat 510?
510-742-5887. 5887. Yes. And make sure that 6 months has passed, okay? Okay. 6 months has passed, okay?
Okay, thank you. Yeah.
Okay, by the way, hold on before you go. Did the I-140 get approved already?
Yeah. My I-140 is approved, and actually my 6 months will be completed in October.
Okay, beautiful. Okay, then let me know when you're ready to come back. If there's any problem, then I'll help you do an AC-21 supplement J transfer, okay?
Okay. Thank you.
Good luck to you. Okay, bye-bye.
Yeah, thanks.
Let me take another caller, Michael. Sam is online. Hi, Sam. Hello?
Hello?
Yes, sir. You're live and in.
Hello?
Hi, Sam. Yes. Can you hear me?
Yeah, now I can hear you. Okay.
Yes.
So, my question is that after marriage, my wife's name in the passport is not changed yet, and I'm in US. My I-140 is approved. So now I was thinking to apply for the EAD, and I thought, and that time I saw the SSN also I can apply. So then I thought, whether is it right time to first change the name in the passport and then apply for those documents, so that in future it will be all synchronization in the name for all the documents. What would you advise?
Sorry to do that. So she's taking your name, right? So you are a U.S. citizen, right?
Oh, no. I have approved I-140.
Okay, and your priority date is current?
No, it is recently got approved.
Okay. So there's plenty of time right now, but if you want to change the name on the passport, go ahead and do that. But when you get married, it's not necessary, but it's recommended to do it because now at the airport they get all confused. So since you're I-45, you're from India, right?
Yes.
Yeah, so there's a long wait. Which category? EB1, EB2, EB3?
It is EB2.
Okay. So there's a long waiting time now, so you have plenty of time to change it. Later on, at the I-45 level, this is when you have to put it exactly whatever name you want to put. Right now, it doesn't matter which name you use because the I-140 just asks for the name of your spouse. So it's not a big problem right now, but it's good down the road to change the passport, the name on the passport.
Okay. So my concern is that later then I have to change in the SSN as well, and all the name changing process will be easy or difficult that time?
No, it's not difficult. For taking the name of your spouse is not difficult. If you change your name completely, then it becomes a little bit more difficult. Then you might have to go to court, get a permission from the state court to change your name, etc. But it's just taking the name of your spouse from the maiden name. It's not very difficult. Okay?
I see. And I have one more question that there are two categories, EB1 and EB2. So EB1, recently I saw on the USCIS website, it also shows the backlog, and they're processing for the year 2012. And for EB2, it is 2009. So it's only just 3 years of difference. Is that correct understanding?
Well, next month is going to be more, because EB2 next month is passing to 2007.
Okay.
So it's going to be almost 5 years of difference now.
I see. Okay.
Yeah.
Okay. Thank you.
But the chances, I need to clarify this for you. The chances of EB1 getting current faster or moving faster is higher than EB2 because there are limited people who qualify for EB1. So definitely EB1 will go faster than EB2. So that difference that you're looking at is not a real difference because one moves slower than the other.
I see. Okay. Thank you.
Good luck to you. So I don't know if I have more callers, Mike. Ladies and gentlemen, this is Attorney Shah Peerally for the Shah Peerally Law Show, and today we are live. It's August 16, 2018. The number to the studio is 510-657-70, and I have Michael on the board with me. And we have some very, very interesting situation right here that we are talking about. A lot of people, for one, we have one issue we were discussing about is expedited removal, and I have a video on my YouTube I just made. And one of the things that you will want to do is subscribe to my YouTube channel, youtube.com/Shah Peerally Law, SHAPEERALLY, and because I put all those podcasts again, and also this is the easiest way for me to communicate now because writing articles is too time consuming and so many issues, and we are so busy right now, so I can't really do so many articles, but I'm trying my best to update people quickly on YouTube, and it goes faster. So please subscribe. And someone told me we have to say click on the bell. So click on the bell to get the notifications. And please share it because I put a lot of information that are very helpful, and people tell me that it helps them a lot to get in that. So also we were talking about the expedited removal. One of the things that you will see I just posted are people who get deported at the airport, and this is becoming very, very common, and they don't realize when you get deported at the airport, they call it expedited removal or summary proceedings. What it does, it bars you for 5 years not to be able to come back. So be very, very careful when you're coming. Even though you have a valid visa on your passport, they might send you back, and it's just like a regular deportation except there's no judge. Let me take another caller, Michael. Hi, Shurab. This is Shah. You're live on air.
Hi, Shah. I have a quick question. My company recently got acquired by another big company, and they have different locations. So my new company, they filed the amendment, and in amendment, I got RFE. And in RFE, it looks like all client-related documents and stuff like that. But I'm working as a full-time, and I have upcoming out-of-country visit is upcoming. So question is, can I go while amendment is in process out of country, or can I go and do visa stamping on my current H-1B application, which is valid till October 2020? So if yeah, go ahead. Yeah, sorry.
Yeah, let me answer the two, and then you ask me the next one. Number one, I don't recommend traveling while the amendment is pending, especially if the previous, what has happened in your case, Company A has merged with Company B. So right now, Company A doesn't exist anymore, right?
Yeah.
Okay. That H-1B that you have is with Company A, and you cannot really use that H-1B because that company doesn't exist anymore. So the only H-1B that is holding you right now is that pending amendment. and that pending amendment is not approved yet. So if you travel right now, there is a chance they won't give you your stamp. Do you have a stamp on your passport?
No, my stamp is expired.
Yeah. So there's a chance they might give it to you, but they might not, because the thing is that it is a merger and acquisition. The only problem is that you change location. So if it was just a full merger and acquisition without a change of location, even with, you don't have to do an amendment, you would have been fine. But right now, in your case, because of the amendment, it creates kind of what we call a liquid state. It's not really what I call a liquid state. It's not really it's a fluid state, as I should say. So what happens is that in that situation, you don't really have a status. You don't really have a good H-1B. And using the other H-1B from company A is not recommended because it doesn't exist anymore. So the risk is pretty high. I'm not saying you might not get it. There's a chance you can get the stamp, but the chance is low. So I would recommend putting the amendment on premium, or get it approved, or answer the RFE quickly, and then travel after the approval. Or if you leave, wait for the approval before going for the stamping.
Gotcha. Sure. And one more on behalf of that question is, let's say if I am out of the country and let's say my amendment is approved here, so can I go for the visa stamping on the basis of my approval of my amendment, but I don't have the actual copy, so can I go with the Xerox copy?
Yes.
Okay.
Actually, that's the way to do it. If you're planning to travel, amendment is pending, wait for the approval, get a copy sent to you by email, and then you can just go there and use that and get your stamp and come back.
Oh, okay. Thank you. I see a lot of time on Trackit. I'm seeing a lot of time right now. USCIS is generating RFEs. So this is now onwards common, or this is something rule is going to be changed?
Everything weird is common right now. Everything. Imagine anything weird. Everything is common. What they're doing is pretty much kind of quote unquote giving a hard time to people, because the idea. What I see in here is they have been kind of instructed to make it as difficult as possible to get an H-1B, and that has not been a secret. So basically at this point, immigrants are now, just like in criminal court, instead of being innocent until proven guilty, now you're guilty until proven innocent. So you have to prove your case harder than any time now. And even cases that were approved before, they're going back. Now, what is going to happen also in September, they will stop the RFE, which is going to create more problems, because instead of getting an RFE where we could defend it, you'll just get a denial, and it's going to create more chaos. So hopefully one will be able to solve this. So answer your RFE quickly, get an approval, leave, or if you leave, wait for your approval and then go for stamping. Okay?
Sure. Thank you, Shah. Thank you very much, and I appreciate it.
No problem. If you need help, call us 510-742-5887. Let me take another caller. This is Shah Peerally. This is Shah.
Hi, this is Ashish here. Actually, the question is related to my wife's H-1B. So recently, her company filed her extension, and the LCA which they submitted has the wage. The LCA wage is higher than what she is getting paid for. So, now she has got RFE on that. So I want to know, what are the chances of approval?
Okay. Let me get it right. Was she paid less than what was an LCA, or now the new extension is they are saying they're going to pay her less than the LCA?
Yeah, so the new extension LCA has more wage than what she is getting paid right now.
No, right now. But then when they filed the extension, what did they put they're going to offer her salary? Are they going to offer her more?
So I guess that they mentioned that, but her current salary slips show that, she is getting less than the LCA wage.
Okay. Hold on. There are two H-1B in her case. Well, two parts. Number one is the existing H-1B. That one, there is an LCA for it. that LCA is being satisfied with the salary she's getting, right?
Right, yeah.
Okay. It's the new one that they have to pay her more, right?
Right.
Okay. So now the question, when they file the case, the new one, what did they put a salary higher than the LCA on the application? Did they say, for example, let's say they're supposed to pay $100,000 on the LCA, and they say they would pay $101,000 on their petitioner's letter? Do you know?
No, I'm not sure about that. If they mentioned that in the petition.
I'm pretty sure they did, because otherwise no good lawyer will do that unless it's a mistake. But it doesn't matter what they pay her before. It's what they will pay her when she gets the approval notice. Unless her case, she's already expired the previous one and is pending on this, then they have to move to the new one. But if the previous one is still good until the other one gets approved, it doesn't matter what they're paying her now. It's in the future what they will pay her.
Okay. So yesterday only she got an RFE on that. So do you think it could be because of the difference in the current wage and the LCA rate?
Yes, it might be. But unless I see the RFE, I won't be able to tell. But if they're increasing her salary, let's say, for example, the previous LCA, I was paying you $75,000, and the new one now is $100,000, and I'm saying I'm paying you $101,000, it can easily be explained. Now we're increasing her. But if the previous one is off, and she's already in a pending situation on the second one, and they're not paying the salary, that might be a problem. So give me a call at the office. We can do a consultation on the RFE, and I can guide you. But technically, it should be okay. It's just a matter of explaining the situation, okay?
Okay, cool. Thank you.
Okay. You're welcome. Good luck to you.
Thank you.
Let me take another caller, Michael. Shri, are you there? Hello? Hello? Hi, Shri. Hello? Hello? Hi, Shri.
Hello.
Hi, Shri. You're live on air. This is Shah.
Hi, Mr. Shah. You're doing a great work by attending a lot of people's calls, and the community is really appreciating your service. I have a simple question. This is regarding my spouse. She is on the verge of getting an I-140 approved. And the major doubt is for us at this point of time is if we move to company B, how do we actually get the I-140 transferred? Is there a chance that we can get this I-140 transferred to the company B?
Okay. Let me tell you two things. Number one, the I-140 itself cannot be transferred unless you have an I-45 attached to it and 180 days has passed. However, once the I-140 gets approved, you log the priority date. That one can be transferred to another company. However, it's very important that if she needs the I-140 to get extension on H-1B or get you H-4 EAD or something, she needs to keep that I-140 alive. The first 6 months of the I-140, the employer has a right to revoke it. So I recommend people not to leave for the first 6 months. Because if they leave and they need that I-140 to get extension of H-1, they will be stuck. Because you have different goals here. So one is a green card, one is extension of H-1B beyond 6 years, etc. So we need to know how many years she has used her H-1B.
Just a couple of years.
Okay, so she's still good. She doesn't have to worry about the I-140, but it's good to have it. Number one, just make sure the I-140 is approved before you leave. Because if you leave, they might just stop the I-140. And number two, if you could wait for 6 months before you leave, that will be better, because at least you can use that I-140 down the road if company B, where she's moving, is not filing an I-140 and she reaches 6 years to extend her H-1B. However, she cannot use that I-140 to get a green card with company B. Okay, there are three things here. Okay, so she cannot use that I-140 to get a green card except the priority date. So company B will have to start over, labor I-140, and borrow that priority date and put it in. Okay.
Okay, it's a fresh process altogether.
Yeah, but make sure the I-140 is approved, because you won't even be able to take that priority date without having an approved I-140.
Yeah, and lastly, lastly a question. If I get an H-4 EAD through her approved I-140, if she moves to company B, I'll have to refile. She has to rework the I-140 again and get a fresh I-140 and then apply for H-4 EAD for me again?
No. Once you get the H-4 EAD, it's already approved. Even the I-140 goes away, it doesn't matter. However, until the H-EAD gets approved, the I-140 has to be alive. That's one reason, more reason she sticks there for 6 months so that they don't cancel it. Because after 6 months, there's a law that was passed in January 2017 when Obama was here that after 6 months, the employer cannot revoke the I-140 unless USCIS decide to revoke it on their own based on a fraud or misrepresentation. So in this case, first get the I-140 approved. Number 2.
Yeah, in that case, H1, yeah, I get it. I get H-4 EAD, which means it's directly proportional to her H-1B status, extension of her H-1B. It's my H-4 EAD will remain alive as long as her H-1B is alive.
Yes, but one thing you have to do, if she moves to company B, make sure they file an I-539 extension for your H-4. You don't have to do anything on the EAD. Only you have to do that, the 539. That means an extension. The reason you do that, if company A cancels her H-1B after she leaves, you still have your H-4 alive attached to company B. Otherwise, if they don't do that 539, what will happen if company A cancels her H-1, your H-4 will go and your EAD will go. So make sure that you just follow that. And if you want, before she moves, if you want to get a personal consultation, give me a call and we'll do that. 510-742-5887. Good luck, Shri, and thank you so much. Kind words. Take care.
Thank you so much.
Oh, good.
Bye.
Let me another caller, Michael. This is Shah Peerally. You're live in air.
Yeah.
Hello.
Yeah, I'm here. Hello.
Yes, sir. Vijay.
Yeah, Vijay here. Hi, John.
Can you hear me, sir? Hi, how are you?
Yeah, doing good, sir. Is it John?
This is Shah.
Yeah, Shah. Sorry. Shah, actually, last week I spoke to you, right, regarding my H1. Are you able to hear me?
Yeah, I can hear you. Just speak a little bit loud. I'm sorry. We have some issues with connection sometimes. But go ahead. Okay.
So the thing is, like, I got a hint from USCIS saying that I stayed out of use on H1 more than 6 years, and then after 6 years, I came back to US and then applied for out of cap H1 transfer and extension. They rejected, saying that you have exceeded 6 years, so you have to come back to US within 6 years and then apply. You are eligible for out of cap. So that's the hearing from them. So, but at the other side, I have I extended my B1 stay. So I am yet to waiting for a hearing for B1. I got the receipt for B1. So can I stay? I read from USA site that I can stay for 1 year, right? On B1. So until I hear
you cannot stay for 1 year. As long as your case is pending, you can stay. If it gets approved, perfect. But if it gets denied, you have to leave. So there's no 1 year. But usually they go extension. Back in the days, they were doing that. They will extend it up to 1 year. But now they don't do that much anymore. So as long as the case is pending, you can stay. If the case is approved, you can stay till the date it's approved. But you cannot just keep staying and staying, no. That's the problem. And for your H1, I remember your case. So basically, once you pass the 6 years, if you have not claimed the H1 left, they kind of will not give it to you. But you can stay as long as the B1 is pending. But be very careful because they might deny it because you already tried an H1, so there's a big chance they will deny your B1 too. So give me a call if anything happens, 510-742-5887. We can look into that.
Can I let know your number, please? One second.
Okay.
Repeat.
510-742-5887.
510.
742.
742. Sorry?
742.
742.
Yeah. 5887.
58?
Yes. And then 87.
58?
5887.
5887?
Yes. Okay?
Yeah, I'm repeating 1 second. 510-742-5887, right?
Yes, exactly. You got it.
Yeah.
Okay?
Yeah, thank you, Shah.
Okay.
I'll call you.
Okay, thank you. Good luck to you, Vijay.
I'm not able to hear properly. Sorry for that.
Okay, no problem. Sorry from my side.
Yeah.
I apologize.
Yeah.
So I don't know how much time we're left, Michael, but we're going to talk a little bit about debt settlement before now. We got a lot of callers, so I don't think I'll be able to take more callers, Michael. So anybody calling, please call the office. We can schedule a consultation, or you can call next week, 510-742-5887. Anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. So just wanted to let you know that, ladies and gentlemen, we were talking about many things that are happening on immigration. And as you can see, people are calling, and this is just a sample of what's happening. There are more issues. Unfortunately, on the radio, I cannot really tackle complicated issues because it takes at least half an hour to 1 hour on one question. So please call us if you need a free, we don't do free consultation, by the way. If you want a consultation, 510-742-5887. Because the thing is that each case is different. So whatever I'm telling you today, what is good for one person doesn't mean it's good for you. So be very careful on that. And that's where people get in trouble, because they read on forums and they get all confused on forums, and they end up by creating more problems for themselves. Forums are good to get timeline. Forums are good to get stories, but not good to get the law. Although they might send you links, if they're pointing to a law, make sure that they're sending a good link. But also you have to be careful what links they are putting for you, okay? Because oftentimes I see links from consulting companies or some supposedly immigration issue, but they are not lawyers there. And the lawyers, even their lawyers, they have to have at least some reputation that they know what they are saying. Even having done that for years, some of the things I don't know. I cannot know it all. I try my best to educate myself at least 1 hour a day on new issues, but you have to understand that you won't be able to get your answer really on those forums. In fact, you might hurt yourself more by relying on them. Having said that, forums are good to actually share views with other people, but be careful when you put your name there, because that can create a lot of more problems down the road. So now let's go back to some of the topics. And before I move to the end topics, I just wanted to talk a little bit about debt settlement. That's one thing that is coming fast. A lot of people, like you heard many callers, they're moving to another country until things get better, or waiting on their green card. And they want to know what happens to their credit cards here, what happens to their house, and et cetera, et cetera. So if you have debts and credit cards, and since you're moving to another country, you might not be making that much money or something like that, and you just want to at least get rid of those without hurting yourself too much, we can do what we call a debt settlement. You can give us a call, and you can visit the blog yourdebtsettlementattorney.com, or you can call 510-742-5887. We can look into your possibilities. We can do that for second mortgages. We can do, second mortgage, it only works if the house's market is down, and in the Bay Area it's not that much. And for debt settlement, we handle only California. So just read a little bit about it, yourdebtsettlementattorney.com, or call the office, 510-742-5887. Now, let's go back to immigration, because this is the main issue that a lot of people are worried about, because they have reasons to. One of the things that we are seeing, a lot of people coming at the airport, especially students with a valid visa, and people coming on visitor visa are getting turned back. Not only getting turned back, they're getting pretty much technically, you will see a stamp on the passport with an A number with a section 235, which is expedited removal, and also 212 inadmissibility. And that's becoming more common than before. In 2014, it started getting common, but now it's commonest. I don't even know if it's a word, but it's becoming really, really horrible. A lot of people coming with a good visa, or even on visa waiver programs, like people coming from Europe, Australia, etc. They are getting turned away, and they're having this stamp on their passport, and those stamps usually carry a 5-year bar, usually, because it's at the discretion of the officer. They might waive that. So be careful when you come. We had different situations. If you have an immigrant intent and you're coming in and you're telling, hey, I'm going to come in and file for a green card, well, of course, you violated the visa right there and you become inadmissible. So be careful on all those issues. The other issue that we are seeing, day one CPT, and I think I mentioned that before, day one CPT and those who are same level education CPTs. So all those problems are going to be hitting hard, and we need to make sure that we cover for all this so that we don't have any problem down the road. The other thing that we are seeing also, people who have taken welfare are going to have a hard time to get their citizenship. So if you need to apply for citizenship and you need help on the N400 application, give us a call, 510-742-5887. And also, we are seeing a lot of issues that are related to a specialty occupation, and I recommend people to at least get an expert to do an analysis and deal with that. And now it's becoming real legal writing. So, ladies and gentlemen, I'm going to close here in a few minutes, so in 1 minute actually, and then Amit will take over. So I just wanted to let you know, if you need any help, feel free to call our office, 510-742-5887. And also, if you need, check our website, attorneyonair.com, and please subscribe to the YouTube channel, youtube.com/Shah Peerally Law. Shah Peerally Law is very important because that's where I put the updates on pretty much on a daily basis as much as I can. And you will get a lot of information there. And check our website, attorneyonair.com. Thank you for listening. We'll be back next week, same time, attorneyonair.com. Anything I told you today is purely educational in nature. If you need any help, 510-742-5887. Thank you, Michael. Take care. Amit, are you there?
Hi, Shah. How are you?
I'm doing well. So I'll let you continue, and then we'll take it from there. Okay? I think you have it.
Thank you, Shah. Thank you.
Bye.
And hello to all the listeners. Your realtor and tax expert, Amit here. Back again. Sorry, I've missed for a couple of weeks last time. I've been quite a bit busy with some transactions, and just came back again today to provide you with some details on what's happening in the real estate market. We have quite a few listings available right now, in the market that